morning. Please be seated. The next matter in order for hearing is the matter of Ed Friedman versus the PUC. Council, as you know, we are live streaming to the public. I'm going to remind you to stay right in front of the microphone because it is directional, and if you will wander, I will ask you to step back. At this point, I'm going to ask those who will be engaged in oral argument to step up, give us your name and the party you're representing so that we can start the official record.
Bruce McLaughlin, representing complainants Ed Friedman et al.
Thank you, Mr. McLaughlin.
Jordan McColeman, representing the PUC.
Thank you, Mr. Coleman.
Catherine Connors, representing Central Maine Power Company.
Thank you, Ms. Connors. And with that, Mr. McLaughlin, you may proceed.
Thank you, Your Honor. This appeal requests that the court vacate the Public Utilities Commission's dismissal of the complaint and remand the matter back for a full hearing investigation on the allegations. It also requests that this court exercise its exclusive authority to protect the constitutional rights of the complainants. In that,
Mr. McLaughlin, I apologize profusely. I'm going to ask you to hold up for a moment. We have an issue with the cameras. Only one. Are we already set up for the pooling? We'll put the time back on, I promise.
appreciate that.
And I think we're all set, and you can go right back to your argument. I apologize for the interruption.
As I was saying, the the appeal also requests that this court exercises exclusive authority to protect the constitutional rights of these complainants by declaring unconstitutional those aspects of CMP's smart meter program that are mandatory and the opt-out fees that are authorized by the Commission. The Commission dismissed the complaint without providing any opportunity to be heard and without entering any evidence in the record. By doing so, it refused to hear credible allegations about safety, privacy, property rights, and discrimination. It abdicated its statutory duties to hear and investigate, its statutory duties to consider all relevant factors when reviewing smart grid facilities, and its statutory duties to protect the safety of CMP customers. The legislature has said that any group of 10 customers or more may at any time file a complaint. And it says that the PUC must hear and investigate unless the allegations are wholly without merit or the causes of the complaint have been resolved. There is nothing in the record or in the briefs on appeal to establish that either standard has been met. We reiterate our objection to the PUC and the CMP relying on non-record evidence to defend the dismissal on appeal. The constitutional issues are straightforward. CMP customers have the right not to have their homes requisitioned as communication facilities within CMP's mesh network system for the smart grid. They also have the right to refuse.
Mr. McLaughlin, can I get to what I think is the heart of your appeal here today?
Please.
The Commission opened an investigation, held a hearing, and issued an order in January of 11 in the Boxer-Cook matter. After that matter was resolved, 10 good and true citizens requested that the Commission think again, particularly about the health-related matters. When the new petition was presented to the Commission, was there new information related to health and safety that was presented with that request?
Within the opt-out investigation you're talking about?
Yes.
I don't know for sure the answer to that. That is not part of this record, but my understanding is that there was no opportunity to present evidence. My understanding is the evidence that was presented by CMP in response to the complaints. They submitted some...
You're now talking about the original opt-out investigation.
That may be. But my understanding is, at the critical early stage, the PUC said we are not going to investigate this issue, and it did not provide an opportunity to be heard on it, did not provide an opportunity to hear evidence on it.
So your point is that the commission made a mistake when it said we have already considered this, and that's the reason that we're not going to open another investigation. Because in fact they didn't consider the health related issues.
In dismissing our complaint. It's our position that as a group of 10 complainants, we have the right to be heard on a subject.
Mr. McLaughlin, I want to ask you about a couple jurisdictional questions. The first is that you've brought a complaint not only against CMP, but also the commission itself. Section 13021 is not ambiguous. A written complaint can be made against a public utility. Under what authority do you have the right to file a complaint with the commission against the commission?
Well, this appeal is not pursuing complaints against the commission. The appeal is pursuing complaints against the CMP for its practices that are authorized by the commission, and it is also pursuing a complaint about the constitutionality of what CMP is doing on the authority of the opt-out orders.
All right, so you're not pursuing your claim against the commission. You waive that.
To the extent that you're saying there has to be a claim against the commission for a constitutional argument, I suppose not. But this is a claim against CMP for its activities as authorized by the commission.
With respect to my second jurisdictional question is with respect to the constitutional questions. The commission is not a court of law. It's a commission that regulates, among other things, public utilities. If you have a constitutional argument to be made against the actions of the decisions of the commission, don't you need to file a lawsuit? Don't you need to seek a judicial determination of your client's constitutional rights, that the commission is not the forum for that type of determination?
I believe that would be poor use of judicial resources, and I believe that the legislature has specifically authorized this court to hear constitutional claims under Section 1320 of the statute, which clearly authorizes constitutional claims on appeals from the commission.
Mr. McLaughlin, let me follow up on Justice Levy's jurisdictional questions. Whose job is it to determine the health risks associated with smart meters? The PUC appears to believe that it is not part of its job.
It is clearly part of the legislature's intent in enacting Title 35-A to ensure the safety of utility customers, and it is the PUC that is enshrined with that obligation, that duty, and that public guardian status to ensure the safety of...
Well, would you agree with me that the PUC seemed to be saying that the FCC is the only entity that can handle those claims or concerns?
I appreciate the word "seem" there because it was not clear at all from the Commission's orders. The Commission seemed to be declining to give any consideration to safety, which is one of its fundamental duties, merely referring to the fact that the FCC has some guidelines out there that relate to safety, but that does not provide the PUC with a fine and perpetual fee on those persons who are exercising their constitutional rights.
If there was no fee, would it resolve the issue in your mind?
It would resolve, in my mind, it would resolve the constitutional issue. It would not resolve all of the underlying complaints that need to be investigated about the safety and privacy issues.
Mr. McLaughlin, could CMP put smart meters in without the permission of the PUC?
No.
Thank you, Mr. McLaughlin.
As I was saying, in addition, clarification of time now. What time do we have? Okay. They say that there's no constitutional concern or trespass concern because every electricity user has consented to the installation of these devices by virtue of the terms and conditions that CMP imposes on customers when they accept service. But terms and conditions that are unilaterally imposed by a monopoly to restrict customers' property rights cannot serve to infringe their constitutional rights.
Mr. McLaughlin, I want to come back, though, to my concern, which is it seems to me what you're asking the Commission to do is to rule on the constitutionality of its prior decision. This is not an appeal from the opt-out decision. This new complaint essentially alleges that there are constitutional problems with the regime that has been adopted as a consequence of that earlier determination. Don't you have to file a lawsuit if you want to raise those constitutional issues, not seek what is essentially a second appeal from what is now a final decision?
I disagree with the characterization that this is a second appeal. This is a complaint about certain activities. Let's say there was, if your position is correct, Your Honor, then no complainant would ever be able to complain about the constitutional, about their constitutional rights with respect to any regulation, activity, terms and conditions, rates of a utility.
Mr. McLaughlin, I think you may be missing Justice Levy's point. We are not here on an appeal from the opt-out order.
Correct.
And the opt-out order is therefore a final order. So the request for a new investigation cannot replow that ground on its own.
I don't understand why. Every rule, regulation, rate of a utility, not every, but many, are reviewed and approved by some final decision by the Commission. So you're saying that even though Section 1302 says that we may complain about any rule, regulation, rate, we can't do it because it's been approved someplace else. That would eviscerate the scope of Section 1302, which was intended by the legislature to allow complainants to come in and complain about a regulation, rate, or practice of a utility, regardless of whether it was previously approved by the Commission.
Thank you, Mr. McLaughlin. Mr. McCollum?
Thank you.
Good morning, Your Honors.
Mr. McCollum, the decision dismissing the petition in this case concludes, CMP is currently implementing the directives contained in the opt-out orders and the orders on reconsideration. Thus, CMP has taken and is taking adequate steps to remove the cause of the complaint filed by Ed Friedman et al. The opt-out orders explicitly disclaim addressing the health and privacy issues which Mr. Friedman and others now wish to raise. So how is it that CMP's implementation of the opt-out orders can be adequate steps to remove the cause of the complaint filed by Ed Friedman?
Well, Your Honor, the CMP's implementation of the opt-out orders means that CMP is offering its customers a means to opt out of the AMI program. And the remedy to the original 5 10-person complaints that the Commission fashioned was to allow customers, if they so chose, to not have a smart meter on their home, which, in the Commission's mind, remedied the health and safety and privacy and trespass issues.
In the opt-out proceeding, the Commission explicitly said that it would not determine the health and privacy challenges that were raised in that proceeding. They cite to information from the Maine CDC. They mention that the FCC is an entity that has the competence to determine these things, but it explicitly says we are not going to decide those issues. So how does the resulting order in the opt-out proceeding address the same issues now raised again that weren't considered the first time?
Your Honor, that if this were an appeal from that order, I think that would be an interesting avenue to go down. But that's not the case here. The order that's on appeal before this court is an order from is an order that resolved a Section 1302 complaint, and Section 1302 complaints are intended for people to bring concerns about activities of utilities before the commission.
Right, and Mr. Friedman's concern about the utility had to do with the health and trespass concerns. Is it PUC's decision that by allowing an opt-out, it can duck an obligation to consider the health or the trespass issues?
No, Your Honor, I don't think that's the case at all. The commission received 5 10-person complaints, consolidated them into a proceeding, and determined that the remedy for all of the concerns in those proceedings was to offer an opt-out.
Well, isn't the PUC supposed to be telling those of us who have to decide whether or not to opt out whether there are any safety concerns?
Your Honor, the public is free to have whatever concerns it would have.
Not when the statute reposes in the commission the responsibility to make determinations about health and safety.
Yes, Your Honor. Again, if this were an appeal from the original opt-out order, what the commission did or did not do or should not have done in that instance.
So you're suggesting that because the commission decided that it wouldn't decide the health, safety, privacy, or security concerns, and I'm quoting now from the January 7th notice, that it is now, those issues now are not subject to review by the commission? They don't have to be considered by the commission when a new petition is brought?
What I'm saying is, Your Honor, that the commission reasonably relied on previous decisions when it dismissed this 1302 petition.
How could it reasonably rely on its earlier decision when that decision explicitly said we're not going to decide the merits of the health, safety, and privacy or security concerns? How can that be reasonable reliance on a prior decision?
Your Honor, all of these issues were before the commission in the earlier proceedings. The commission had a proceeding on this and
But it didn't decide any of those issues.
No, Your Honor. The commission did not. The commission decided that the remedy for those issues, without determining whether or not smart meters were safe or unsafe or there were privacy concerns, the key here is that...
Right, I think I get back to my first question, which is, by declining to make any decision about whether they are safe or not safe, or whether they raise any privacy or trespass issues, by giving the people who currently use CMP an opt-out from the smart meters, it does not have to do what the statute requires it to do, which is determine whether there are any safety issues.
Again, Your Honor, this is not... The case that is before this court is not about what the commission should have done in another case. It is about whether the commission properly dismissed a complaint filed under 1302, and there are 2 grounds for dismissing a complaint under 1302, whether the complaint is without merit or whether the utility is taking adequate steps to remove the cause of the complaint. In this instance...
So which are the adequate steps to remove the cause of Mr. Friedman's concerns or complaint about the health issues?
If Mr. Friedman has a concern about the health issues of a smart meter, he doesn't have to get one. He can exercise his right to opt out.
How about the members of the public that are not opting out? Isn't it the commission's responsibility to look out for their health and safety and to make a judgment as to whether they are being unreasonably exposed to RF?
Your Honor, the commission, as part of its opt-out program, instituted a communications ordered CMP to institute a communications program, which has information for the public. They can go to CMP's website to get information.
Mr. McCollum, what the commission is doing, as you presented, is saying to those of us who must make these decisions about whether we will opt out, it has declined to do the health and safety analysis. You're on your own. Is that what the legislature intended?
Again, Your Honor, respectfully, if we were here on appeal of the original case.
But you've just indicated that there are several reasons that it's appropriate for this request for an investigation to be dismissed. And it sounds to me as if you are importing concepts of res judicata or collateral estoppel into this area. The commission, you say, has already done this work. But I'm back to Justice Gorman's question. The commission, in fact, declined to do the analysis the last time around. Is an opt-out provision an appropriate substitute for having the commission exercise its statutorily presented responsibilities and authority to make the decisions about health and safety?
Your Honor, it would be inaccurate to characterize what occurred in the previous decision as the commission ducking the issue or not examining the issue. There was evidence presented to the commission about smart meters. The commission cites that in its order dismissing Mr. Friedman's complaint. The commission had a study commissioned by the Maine Centers for Disease Control that found that there was no credible evidence that smart meters were...
But the commission didn't make that determination.
No, Your Honor, and the commission also made the determination that it was not the appropriate agency to make such a determination, that there were other agencies that were more...
Why is that? I'm intrigued by that. It certainly is the agency that's charged with making those types of determinations, and like a lot of things, they can consider the Maine CDC's opinion, they can consider the FCC's information, they can consider the information Mr. Friedman presents, and make an informed judgment. Isn't that their duty?
Your Honor, the commission's duty is to... Nothing in the world can be made absolutely safe.
Is it significant that there may be some new science that may have developed since the earlier proceedings that would be appropriate to view here? Or is the commission going to, I won't say duck, I'll say defer or abdicate its responsibility and basically hand back off to the public again? Is there new stuff out there that should be addressed at this time around?
There was no new stuff raised by Mr. Friedman, Your Honor. The study that Mr. Friedman submitted with his 10-person complaint was a study that was before the commission in the previous proceeding.
If there were new science, would you have the duty to dig in and say, okay, we have the duty to answer this question?
That would be a different case, Your Honor. But if the commission were presented with a study that was dramatically different from that which the commission had already looked at, the commission may, in fact...
So are you admitting that they're not safe? Because I think that's what you were starting to say, that nothing in the world can be made entirely safe. Is it the PUC's position that these are safe enough?
Your Honor, it's the PUC's... The PUC looked at the science that was available to it and the science that was submitted, made a determination that it was not the appropriate agency to make a final ruling, did not see anything in what it looked at that led it to the conclusion that smart meters were not safe.
I'm going to give myself permission to ask you a question beyond the red light.
Of course, Your Honor.
The PUC didn't actually make that finding. They did not say, we've looked at all the information, the health studies are in equipoise, we conclude that there's not enough information to say these are unsafe now. Had they made that finding, I would understand your argument. What they said was, we've looked, we decline to assess the information that's been presented. So my question to you is, why are they not now required to do that assessment by law?
Because, Your Honor, the remedy that the commission fashioned removes the cause of Mr. Friedman's complaint. If Mr. Friedman has a concern about the safety of smart meters, he does not have to have one.
Okay.
You may.
But Ms. McCollum, there's still all those people that have them. And for those people, you're saying that the state of affairs can be that the commission can take no position on their safety?
And leave it up to the utility?
No, the commission instructed the utility to, in its communication plan, to provide information to all of its customers about smart meters and links to the science that is out there.
The commission's position is that it's up to the public to figure out whether it's safe or not?
The commission's position is that the commission looked at the health and safety information that was presented to it, did not see anything that would lead it to the conclusion that there was any health risk to them.
Where does it say that?
Where's that in the record?
Did they ever put that in writing? I don't see that in any of their orders, that they did not see anything.
It is not specific in the orders, Your Honor, but it stands to reason that if the Commission were presented with credible evidence, as Justice Meade said, that there was a grave danger to smart meters, the Commission would not have allowed them to go on people's homes. The Commission was not presented with such evidence.
Thank you, Mr. McCollum. Ms. Connors?
Thank you, Your Honor. And I just want to focus on what the court has been focusing on. And I think the court may be misapprehending what the PUC did rule. You're saying what exactly did they say about health and safety? I think a good summary of what they said in the opt-out investigation. And the opt-out investigation, there was a lot of evidence on health and safety. That's the exponent testimony we rely on, for example. And with regard to what's in the record in this case, in their complaint, they expressly incorporate all the evidence from the previous proceedings. So all of this is evidence. And in that, the public advocate asked the CDC to review this. So the CDC reviewed it. And the CDC said there's no credible scientific evidence that reflects this, that there's a concern. The FCC said there's no credible evidence that reflects there's a concern. So what the PUC said was, in light of the state of this record, where there's no credible evidence that there's a concern.
Can you point us to where you're getting what the
I think there's a good
Commission
summary
said?
at the Supplement of Legal Authorities 29, the bottom, proceeding to address health issues. And then it's a motion to reconsider that's being denied in the opt-out investigation. And it's discussing its initial notice of inquiry, and it's giving a summary of that. And it's saying, in light of these studies, we don't think we could add anything to the learning. We don't have the authority or the expertise to say, FCC, you're wrong, or to further investigate it.
So Ms. Connors, rather than paraphrase, the Commission, this is, I hope I'm at the right place.
Considering the number of studies that have already exist on the topic and the review conducted by the Maine Center for Disease Control, a review by the Commission of these materials of health and safety would not advance the state of scientific or medical knowledge of the issue.
Didn't that misapprehend the Commission's statutory responsibility? The Commission is not required to advance the state of scientific or medical knowledge. The Commission is required to make a determination about public safety. And if the Commission had looked at all of these various experts' assessments and concluded that nothing in those assessments persuaded them of a public health risk, it should say so. It did not say so.
Well, what happened here is, you are exactly right that if they had said, if there had been conflicting credible scientific evidence, and they had said, we believe this side, we don't believe this side, then we wouldn't be here today. Instead, what they did was they said, oh, look, there's credible evidence on one side, there's no credible evidence on the other side, so what we are going to do...
They didn't say that, Ms. Connors. I know had you had an opportunity to help them draft, we might have a clearer idea of where we are, but they didn't say that. They didn't say all of the evidence before us indicates that there's no credible health risk presented. What they said was, we will not address the health issue. There are so many ways they could have said to the public, here is what we know from what we've gathered from the experts, and they said none of those things.
What they said was, given the state of the science, we believe that the opt-out procedure is the best way to go, because people have sincere concerns about this. And they didn't go into the issue of, is it safe or not?
I can't find, what you just said, I can't find any of their orders.
That
is that given the state of the information that we have, we're not going to conduct any investigation of our own. That's what they said, nothing more, nothing less, right?
Because there was nothing they could add. There was nothing...
Well, what they could have added was their judgment. They could have said, and therefore, based upon this information, we conclude that it's reasonably safe. They could have said that, but they didn't.
Well,
that would have required a weighing of the evidence. As you said, looking at the other evidence, perhaps finding it less than persuasive, and making their institutional judgment that the program is safe.
But
that's not in this record, right?
They made the decision that they didn't have to go through that ultimate decision of, are we going to force everybody because we think these are safe to do this? We're going to say, we don't have to ultimately resolve the issue of what is safe and what is not, because what we can say is, if you opt out, there's no problem. And that's what we believe is the right way to go on a cost allocation. And what I think the court needs to understand is all of this is cost allocation. We can put in meters if we want. The question is whether we're going to get paid to have these meters. And what the PUC said was, if you buy this kind of meter, you pay this. If you buy this kind of meter, you pay that. That's a rate design decision.
And I'm just going to get back to the earlier issue, and the PUC has left the public without its judgment on which way the public ought to opt in an opt-out situation.
Because it didn't need to do so as a part of the review of this complaint.
Thank you, Ms. Connors. Mr. McLaughlin, anything in rebuttal?
Yes, Your Honor. To emphasize...
McLaughlin, over here.
Yes.
Isn't what happened here is that the PUC ducked the health and privacy issue by adopting the opt-out provision by saying if you have a problem, you just don't have to take these meters. But in doing so, it really raises two additional questions, what I think is what you're coming at. One is the safety of those who are not opting out and the extra fees for those people who are opting out. Those two issues remain out there, is that right?
Absolutely. As Justice Levy has been emphasizing, the safety of all the other folks is ignored here because the PUC has failed to address that issue. But also, the fee, which really is a penalty, regardless of the rationale they may suggest for it, the fact is that it has a coercive effect that is similar to a sanction or a penalty. People are refusing these meters because they're afraid, because they fear for their safety and their health, because they want to protect their privacy, maybe just because they want to stand on their constitutional or property rights ground. But what do they have to do? They have to pay a perpetual fee. And because it's in response to their exercise of constitutional rights, it should be the CMP's burden to prove that there's a necessity for this fee to...
The PUC came back after a study and found and made a finding that it was safe. I mean, if the PUC came and had a hearing and said it was safe, would the fee then be justified? That you'd have a choice of having this efficient meter or do it the old-fashioned way?
It's not only safety, it's interference with property rights, it's trespass, it's a taking, it's a search, and it's a violation of privacy.
Assuming they resolve all those issues.
Resolve all those issues? I don't know how they resolve those issues without giving full ability to opt out without a fee or penalty. I would emphasize that not only did the Commission not decide safety and not make a judgment about safety, it did not allow people to be heard or to provide evidence on safety. So even if it had a better scrivener of the order, it would have been inadequate because of the fact that they didn't take evidence on the issue.
Thank you, Mr. McLaughlin.
Thank you.
We appreciate the briefs and argument of counsel. We'll stand in recess.
All rise.